This is You and the Law on AM 650. Now back to the show.
Welcome back. David Hobbs and Ian Giroday from Hobbs Giroday in Vancouver with us on this edition of You and the Law here on AM 650. David and Ian are Vancouver estate litigation lawyers with offices in downtown Vancouver on Howe Street. Gentlemen, you've had a couple of minutes to respond. Not that this is a surprise or hard question for you. This is what you do for a living. But what happens? What happens when someone dies and there is no will? We've talked about administrators and executors and documents and court probate permission and all. That's all assuming you've done the right thing and you've had a will. So you die and there is no will. Now what? David?
Well, there's nobody to pay your bills, to distribute your assets, to deal with your estate. It's assuming there is an estate, whether it's a car, a bank account, a house, or a combination of things. Somebody has to deal with those assets, and there may be liabilities as well. You may owe some money to Revenue Canada or the Hudson's Bay or the Shell Gas Company, but somebody has to deal with that. And if you don't have a will, you haven't appointed the person, the executor, to deal with it. So this executor has to be found now, and there's a process under the Estate Administration Act, and there has to be a court application brought and an order made of the court appointing the administrator, and we call the person the administrator rather than the executor, but they're the equivalent.
Okay.
And that's how that whole process now has to take place. And then there's no will for the administrator because the will instructs the executor, but there's no instruction. What do I do? And so the distribution the instructions again come from the act, from the legislation, and it tells you how that estate will be distributed.
So in British Columbia, Ian, if you die without a will, the state kicks in essentially as your executor. There is an infrastructure in place that says, okay, here's another person who doesn't have a will. Okay, this is what they get. And they get this template that everyone gets, including the appointment of an administrator rather than an executor that you could have chosen had you done a will in the first place.
Yes, there's not... The law, the written law, doesn't put in place an administrator for you, but it provides a process whereby a person can apply to administer someone's estate who dies without a will.
Okay.
But the Act, as David said, the Act does determine how the estate will be distributed.
Okay.
And we often see battles where there's no will, and there may be siblings or children, and more than one person wants to be the administrator. So they come to court and they file affidavits and they explain what a wonderful relationship they had with the deceased, and how bad the other person's relationship was and why they should be the administrator, not the other person, and so on and so forth. So that becomes a dispute.
This is a full-on fight. And they haven't even got into the details of the estate, should there even be one. These are people who just want the right to be at the pointy end of the spear.
Can happen that way.
Interesting. Yeah. So in the case, Ian, where there isn't a will, does this automatically mean a more technically involved process and the likelihood of dispute to be greater?
Not necessarily. In some regards, the fact that the distribution is set out by the Act gets rid of a lot of the gray area that you have with for example, the possibility of a wills variation claim.
Okay.
So, in that regard, it's less complicated, but in terms of just sort of getting the ball rolling and having someone step forward and into the vacuum that's been left without the appointment of a representative,
right?
That can be a little bit more. Well, certainly can be more involved than an executor applying for.
And it sounds also like it's going to be more time consuming if you've left those details unattended to, and the state is essentially obliged to come in and tend to them on your behalf. The state's not going to be in any kind of hurry, is it? You will just get a number and get in line, and your turn will come when it comes.
Well, it's really up to the people applying to get the ball rolling. The Act it's just there. It's not like the state is doing anything.
Okay.
Except providing a process through the written law as to what someone has to do to get on board as the administrator. of the estate and get on with dealing with paying assets or paying liabilities and distributing assets.
So we have two terms for basically the same job, David, if I'm understanding this. The executor is the person who administers the estate appointed by the person who wrote the will. The administrator is the person who also administers the estate. However, this person has been appointed in many cases by the courts.
Correct.
Okay, same job.
Yeah, and the word executor really derives from the word execution. We speak of executing the instructions that are in the
Sure.
will.
Okay.
That's the concept there. Administrator, you administer the estate. Both people are trustees, which is a more general term of anyone who's been given some things with some instructions and other people have an interest in it, and we call that the beneficial interest. So you have trustee, you have the trust assets, and you have the beneficial interest.
Ian, if I appoint someone to be my executor and I pass on, and there are people in my family who are beneficiaries of my will who aren't impressed with my choice of executor, not in the least. Can they apply to have that person removed despite the fact that I specifically requested that individual to be my executor? Can they challenge that?
They can, and sometimes there's good reason to do so. For example, before you pass, there could be the person may have become incapable. But normally a challenge like that will only arise where perhaps a conflict of interest is identified. Perhaps there's a scenario where the appointed executor is holding a piece of property or a significant bank account by way of perhaps a joint ownership or right of survivorship.
Oh, okay.
That the beneficiaries believe belongs to the estate. In other words, perhaps it was set up as a matter of convenience to avoid probate fees.
Mm-hmm.
But the executor's taking the position, no, that was a gift to me. So you can have a scenario there where the beneficiaries might say this person isn't fit to represent the estate because he or she's in a conflict of interest.
Have you ever had anybody come to the office, David, and say, well, here I am. I'm in a real pickle now. So my brother wanted me to be his executor, so I'm here to find out what an executor does. But I got to tell you, Mr. Lawyer, I'm not the least bit happy about this. I don't want to be his executor. Can I refuse?
Well, you can't stop a person from writing your name in the will as an executor, but you don't have to accept the appointment. So when the person passes away and you're named, you can say, I renounce. I don't wish to be the executor. And then if the will doesn't provide for an alternate, or another executor, might be a joint executor, then you can get into our administration problem where we need to have someone appointed.
And do people have second thoughts or get a little antsy about this and refuse, say, thank you, it's very flattering, I appreciate your confidence in me as a human being, and I love you too, but I don't want to be your executor. Can you do that? Is it better to do that to the individual that wants you to be, or do you wait until afterwards and decline then?
What I think surely if you have a conversation with someone who's preparing a will and they say, would you be my executor, and you don't want to be, then you definitely should tell them no, thank you.
You should say no right up front.
And you would not expect them to put you in the will anyways. That would be unusual, but I suppose possible. But no, I think it's a good idea for people preparing wills and prospective executors to have a conversation and an understanding, and that gets back to knowing where the will is, and also in a good discussion you would know about the estate. They'd say, here's where my banking is, and here's where my papers are, and here's where my this and that are, and make the administration easier so it's not looking for something that you can't find.
Ian, it sounds like communication is a pretty critical part of making things successful, making the wheels turn through this whole process of probate and the resolution of the estate and so on. And so if the individual that you want to be your executor doesn't want to accept the assignment, better that should be discussed up front, way ahead of the game, so you can make appropriate adjustments while you're still around and capable of doing that.
Absolutely, Sterling. And, it goes further than that, because you may well want to, first of all, find out whether they're willing to do the job. And if they are, you can lay a lot of good organizational groundwork while you're still alive.
Sure.
Okay, well, here's a copy of the will. The original's going to be here. here's a list of my bank accounts, what institution, what the account numbers are, and so forth. So you can really assist your executor while you're still alive with the task that he or she is taking on.
And I suppose, and this goes back to an earlier question, David, if there is to be some compensation for the assignment that you take on as executor of this person's estate, perhaps that should be included in that initial conversation, whereas Ian says you can cover a lot of ground and be even more helpful than you imagined.
And compensation of executors is an area of dispute because if the will it doesn't specify specific compensation, it can be anywhere from 0 to 5% of the gross value of the estate, and then there's a management fee on top of that for any income generated. And so what happens is at the end of the administration, the executor says, well, I think I'll take 4%. And we might be talking about millions of dollars, and 4% might be a lot of money.
Yes.
And the beneficiaries are going to say, well, that seems a bit rich to us. Tell me what you did and why are you entitled? So that then becomes a fight, because if the beneficiaries won't waive and won't agree to that account, then the executor has to pass the account in front of the registrar of the Supreme Court, and they have to basically prove their fee, which means proving all the work you did in the administration of that estate to justify that fee.
Now, you mentioned, both of you have mentioned already in the course of this program that, and it's very easy to imagine, that all of these wills don't get resolved amicably. There is sometimes some pretty strong emotion and some nasty feelings going back and forth. Do executors get sometimes caught in the crossfire? Ian,
Sure.
Does this happen?
Yeah, I mean...
And how do they handle it? Again, they know, okay, I'm going to be an executor. I'm in your office. This family, whoa, they're a wild bunch. I'm right in the middle of what I know is just going to be murderous crossfire. How do I survive? Has that happened?
It sure has, Sterling. And, one of the things that we do see in our practice is sometimes, especially with a blended marriage, with a second marriage, so you have adult children from a first, then you have a second spouse and his or her family.
Sure.
And they're not getting along very well. And the deceased has appointed a close personal friend to sort of walk through the minefield, so to speak, because they're relatively neutral to either side. But that person can be taking on a big headache dealing with people on either side. And to David's point about the idea that you can elect not to take the job, what you do is you actually file a document in the probate registry saying, I renounce.
Oh, okay, because you've been named in the will, then you
Right.
have to respond to that having been named.
Right, but the point I want to make here is that you can't put your foot in the water and test the temperature for too long before you renounce.
Oh, okay.
Because if you start to act as an executor, it's called intermeddling, and you will not be able to renounce once you've gone into the fray, so to speak.
Okay, so
So it's a
once you're
decision-
in, you got to make the call up front.
Exactly.
Okay. And judging by the sage nod I'm getting from David here, not everyone does that and has kind of chickens out after not only the toe, but the entire foot up to the ankle is wet. And that gets messy too, doesn't it?
Yeah, no, I think people are well advised to get a little advice before they start, because this concept of intermeddling, it's easy to trip into it. You go to a bank, or maybe you deal with the remains of the deceased, or maybe you take a little step this way or that way, and now you've committed,
Right.
and you can't refuse the job now easily. There are some very unusual circumstances where you can get out, but it's tough, and now you're in for a penny, in for a pound.
This is You and the Law here on AM 650. We're speaking with Vancouver estate litigation lawyers David Hobbs and Ian Giroday from Hobbs Giroday, and learning more about executors, administrators, and wills and probate, and there's a lot left on this edition of You and the Law, so stay with us. We'll be right back.
There's more of the show still ahead. This is You and the Law on AM 650.